Okay, we're good.
Okay.
Yes, sir.
Okay, we're live
let me-
finally.
Let's
Okay,
see.
thank you, Travis, for working through that technical difficulty for us. I would like to
Hold
call.
on.
Okay.
Let's see. Let's get. I have another problem here.
Travis,
Yes,
before we
Okay,
jump
we're
in,
live
may I just clarify
Okay,
that?
thank you, Travis, for working through that technical difficulty for us. I would like to
Hold
call.
on. Well, I'm getting feet. Hold on. Maybe it is working. Let me see. Where is it?
Travis, before we
Okay,
jump in,
we're
may I just clarify?
Thank you, Travis, for working through that technical difficulty for us. I would like.
All right. All right. Can anybody hear me?
Yep, I can hear you.
Okay. Let me see. Let me see what's happening here.
Yeah, I can hear you.
Okay. Well, when I go to the YouTube, I'm getting just a blank, getting an error. Let me see.
When I go to the link, I see us all.
Can you see us?
Uh-huh.
Okay, because I cannot. Okay.
Okay, so sounds like I got feedback.
Well, that's because I've got all kinds of stuff going on here. Okay. All right, bringing Bob back in. Lynn says she can see it. I cannot see it on my end, but we must be good to go. Okay, Lynn, you said you can see it on the link.
See it.
Okay, we all set then?
You just have to close the link.
Did.
Okay.
Technology.
Yeah, no worries. I just want to know when we're good to go.
Well, I know that we're streaming right now.
Okay.
So I think we're just trying to get Bob back in the room and then
Okay.
we are ready to go. So
Okay.
anyone who may be listening via live stream, just bear with us just a moment as we work through a little technical problem that we had.
I show Bob coming in and then went back out again. And I don't show him there. Well, okay. His box popped up. He should be there now, or at least there he goes.
Looks like we got Bob back.
Hey, Bob. Well,
Would we need Bob to just call in?
Yeah, that's my thought, is to give Bob the call-in number.
Yeah.
And
Yeah, it's easier for me, so that's why I do it.
okay, I just spoke with Bob and he's going to try to call in.
okay, thank you.
He said when he views us, we are all frozen, just as when we view him, he was frozen. So I'm not sure exactly what the issue is.
I still don't see Bob. I believe this is Bob coming in now.
Yes,
Okay. Travis, would you
Sorry
do me a
about that.
favor? Would you do me a favor, Travis, and just do a quick roll call and make sure everybody's here?
Yes, I have Chairman Tim McFalls. I have Board Member Bob Finnegan, Board Member Terrence Dix, Board Member Marcia Brown, Board Member Sherry Barnes, Executive Director Lynn Bailey, and Attorney Rachel Mack.
Hearing that, it would appear that we have everyone pertinent to the call available to hear as we open this official special call meeting of the Augusta-Richmond County Board of Elections for the purpose of reviewing a challenge, if you will, that has been brought to us by an elector in Augusta-Richmond County of 3,753 voters alleged to be ineligible to vote in this upcoming election. As you guys know, December 7th was the deadline for any new register voters to vote in this upcoming election. And as such, it would appear that this is a challenge for those individuals that are on this list to be ineligible to vote in this upcoming runoff election. What I would like to do, without any objection from the board, is to ask Lynn for some background on the process, how we handle challenges, so that those who are listening in or viewing in either now or in the future would be able to understand what this process is. And also, if she would, please to give us a summary of analysis of some of the names, or some of the voters rather, not the names, obviously, but some of the voters that are on this list, and to give us the data associated with that. Without objection, I would like to throw this over to Lynn. Lynn?
Thank you, Mr. Chair. As the chair said, the office is in receipt of a challenge filed to the eligibility of 3,753 voters to cast a ballot in the upcoming January 5th election. I'd like to start by, well, you all have a copy of the challenge, and
Yes.
for those who have not seen it, I think I'd like to start by quickly reading the challenge so that the people that are viewing might know what it is we're talking about, and then I'll move into then I'll move into the appropriate law. So this is from voter Jeremy Coughlin. As a registered voter of Richmond County, please accept this correspondence as notice pursuant to OCGA 21-2230 of my challenge to the qualifications of certain individuals on Richmond County's voter list to participate in the runoff election on January 5th, 2021. The grounds for my challenge are that I have evidence that there are approximately 3,753 individuals registered to vote in Richmond County who reside outside of the state of Georgia. This information was gathered by running the Richmond County voter registration database against the National Change of Address Registry. The letter mentions a few other things, but let's see. It says, as we know, Georgia law states that no person shall vote in any primary or election held in this state unless such person shall be a resident of the state and of the county or municipality in which they seek to vote. Georgia law specifies several rules for determining residency. For example, Code Section 212217A4 states that Georgia residency is lost if a person removes to another state with the intention of making it their residence. Mr. Coughlin goes on to say that he believes that each of the individuals named on the attached with the attached list of voters as a result of registering their name and change of address to a location outside of Richmond County, removed to another state with the intention of making the new state their residence. Thus, each individual has lost their residence in Richmond County, and consequently, each individual is ineligible to vote in Richmond County. He respectfully requests that the Board of Elections immediately consider the challenge and determine whether probable cause exists to sustain the challenge, and then to notify him of our findings, of the board's findings. So that is the challenge that we're looking at today. Again, as mentioned, in Mr. Coughlin's letter, the grounds for the challenge are based on the belief that 3,753 individuals registered to vote are registered to vote in Richmond County, but reside outside of the state of Georgia, and pertains to these voters' eligibility to participate in the January 5th election. It's important to distinguish what the grounds are and for which for which election, if any, it applies towards, or does it, or whether or not it applies to their overall eligibility to stay on the list of voters, period. This particular challenge pertains to participating in the January 5th election only. And so with that, I'd like to go through the law that and just kind of lightly touch on what 21-2-230 states in terms of the procedure, the board's responsibility, and so on. And then we'll hear from our attorney to talk to you all about probable cause and what establishes probable cause as we continue to discuss this matter. So basically, that section of the law that I mentioned provides that any elector of Richmond County has the right to challenge another elector's eligibility to participate in an election or to remain on the list. There are very few requirements for doing that. The challenge has to be in writing. They must state the grounds. The challenge has to be issued before a person actually steps into the booth to vote. So in other words, anyone who has already voted is ineligible to be challenged at this point. The board considers the challenge and determines whether or not probable cause exists to sustain the challenges or deny them. Probable cause is defined by in Black's Law Dictionary as reasonable ground for belief in the existence of facts warranted from the proceedings complained of. And so Rachel will kind of break that down, into and give you a little more details about that in a moment. But as the board goes about its deliberations and makes its final decision, what they should keep in mind is if no probable cause is found to exist, then the challenge is denied. If probable cause is found to exist, then the affected voters will be placed into a challenge status. And if practical, we would be required to notify the voters. And so if the board should find for probable cause and these voters are challenged, then we would set about marking those voters in such a way that they would appear in a challenged status as they approached a poll worker, whether that's during advance voting, during election day voting, or when the absentee ballots come in through the mail. If a challenged elector does come in person to vote, they would be voting a paper challenged ballot, much like provisional voters do now. The board would then at some point after the election be required to set hearings to have these voters come in that voted to tell their side of the story, if you will. The person who brings the challenge, the onus is on them to provide evidence to the board that the person's right should be challenged and upheld. If the person doesn't vote, doesn't present themselves to vote, or doesn't vote an absentee ballot during this election, then there's no further action required. Under these circumstances, since their right to vote in this election is what's been challenged, if they don't vote, then there's no further action for the board to take, because this challenge is not asking you all to determine their eligibility to remain on the list. If the elector votes an absentee ballot, then that ballot would be marked as challenged. And again, much in the same way the paper ballots that might be cast at the polls would be determined. The board would set a hearing, ask the voter some information that again, the onus would be on the person making the challenge to prove that the individual's ballot should not count. And if that's done, then we wouldn't count the ballot and the person would remain on the list.
Are there any questions for Lynn pertaining to the brief summary that she just gave us and that's just been received into your hearing?
No.
Okay, Mr. Chair, with that, then I'd like to ask, if it suits the chair, I'd like to ask Ms. Mack to step forward and talk to the board a little bit about probable cause, and then we can answer any questions that might come up.
Please do.
Good afternoon, everyone.
Hi.
Basically, what probable cause is the existence of facts, evidence, or some type of circumstance that would make you, as a reasonable person, think that a person accused of something committed that act. So in this instance, you're basically saying there's enough evidence presented to you today that you can surmise that the person on that list is not registered to vote. Does not reside at the addresses that they state they would, so they'd be ineligible to vote in this election on January 5th. In this case, the evidence we have that was presented by the challenger were the two lists, the voter list and the national change of address. So that's the evidence. That's the only evidence we can consider.
Are there any questions for Rachel from the board pertaining her definition and her explanation?
Yes, Mr. Chairman. My question to the attorney is, so according to your reading of this, is there evidence, is this evidence that the board can act on right at this moment? Is that your contention?
If I may, Rachel, because that puts you in a difficult situation. To the board members, Rachel has given us basically her interpretation of the law. It's going to be up to the board to determine whether or not the information that's been provided, the names on the thumb drive that have been provided to us, it's for us to determine whether or not the names on a thumb drive rise to the level that would require us to take an action to either disallow these voters or to allow these voters to continue. I think, and if I'm incorrect, Rachel, then you're welcome to answer the question. But I think that if your question to Rachel is, does she think that this rises to that level? I think it's her responsibility to basically give us that information and then for us to determine based on what each one of us thinks to come up with that determination. And if I'm wrong on that, then please correct me, Rachel.
No, that's correct, Mr. Chair. It's up for the board to decide if you all believe that's enough evidence.
All right,
So,
thank you.
Yes, sir. Thank you for your question.
Chairman, that's all then. Yeah, no problem.
Okay.
Yeah.
All right.
Yes,
Thank
Mr.
you.
Chairman, I have a question.
Yes.
Yes, these names that were submitted with change of address, could some of them be, for instance, military that have a residence here and are out of state or out of the country due to their military service? Or could they be also maybe students that are attending college or whatnot that plan on coming back? And is there any way that we can tell whether or not they fit in those categories?
Well, I'm glad that you asked that question because Lynn has done a preliminary data dive into some of the list. And Lynn, if you would please provide us with a summary, if you will, of some of the data that you've been able to determine out of the names that you've been given.
Sure, I'd be glad to. Yes, as we talked about earlier, there are 3,753 names on the list. Of course, there's no way that we could, in the short amount of time that we've had with the list, there's no way that we could look up and completely investigate all 3,753 cases. And let me just add, because I failed to do so at the top of the meeting when I was talking about the nature of the emergency meeting, just to be clear, we know we went into this meeting with short notice, but we are in the middle of early voting and voting by mail right now. So, it was imperative that the board go ahead and meet and make a decision on this. But it does mean that we have not had a lot of time to look at this list. The list from the state, they were gracious enough upon request last night to take the names that were provided on the thumb drive and at least verify whether or not the individuals on the list were in fact even registered voters. So these are things we don't know. We have a list and we aren't 100% sure of the origin of it. I mean, we know it came from the voter, we know that, but we don't know about the background data that caused this list to be developed. And so I sent it up to the state last night. They came back this morning about 10:30 or 11, I guess, with some information that I thought was very helpful. So we have determined that all 3,753 are in fact registered voters in the state of Georgia. And they did that analysis for us by comparing the voter registration number in the state of Georgia system against that same number that was contained on the list. So that was good. So we know that they were all registered to vote. 37 of them, however, are not registered in Richmond County. They perhaps were at one time. I wouldn't know without looking at all of them. But I know that there were 37 people on the list that were registered in different counties in the state of Georgia. I also noticed just scanning, doing a really high level look at the list. There were, I counted 64 mailing addresses that used, Bob, to your question, that used an APO, an FPO, or an AE as their mailing address. And for those who may not know what that means, those are military overseas, post offices.
Okay.
I also know that 84 names on the list were ballots that were sent out electronically. And so that tells me that those were also military voters, because those are the only class of people that get electronic ballots. So that was an easy piece of low-hanging fruit to identify. We know that 41 people on the list have already voted during early voting in person. We know that 179 people on the list have been issued an absentee ballot. I'm not sure of that, how many we've gotten back yet, but we do know 179 have been issued an absentee ballot. So that's the information that I know about the list.
Thank you, Lynn.
Mr. Chair, I have a question.
Yes, ma'am.
First of all, these 3,700 have been challenged, but that does not stop them from voting. Their vote would just be put in a challenge status, which would mean that it would come to the board very similar to a provisional ballot, correct?
Yes, that is correct.
So no matter what action we take today, these voters are still going to be able to vote. And then it will come back to the board to determine if, in fact, their status, as you said, you found a number that were registered in other counties. Some we know are military, and that certainly would mean that they would vote here in Richmond County. But we need, my problem is the short time we have available to make decisions. But if it does not stop anyone from voting, it simply just puts their ballot in a different category at this time for us to look at, correct?
Yes, that is correct. So if this board, again, should decide that this was probable cause, or there was probable cause to push on with this, these 4,000 voters would be put into a challenge status. Again, if they appeared in person to vote, they would be asked to step aside and vote a paper ballot. The board would then would be required to schedule hearings on them, and those hearings would have to be held prior to the certification of the election results, so that there would still be a lot of work to be done. The voters, I think in fact, I'm sure the notification requirement from the time the hearing, we have to give the voters at least a 3-day notification period of the date, time, and place of the hearing. So all those steps would be required prior to certification. I think the biggest concern that I would have as an election administrator, we would, obviously if we move forward and decided that there was probable cause, I would, want to make sure that all of our poll workers, this close to the election date would need to make sure that they're trained and they know how to process it. And that if a person's in a challenge status, that doesn't mean that they are that they cannot vote and must be turned away. It's a special status that they very, very, very seldom see, and it looks different for them than it would otherwise. So, there would be lots of administrative things to make sure we had in place.
Madam Director, this is Terrence Diggs. I'm sorry, Sherry, were you through?
Yes.
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 Okay. My question would be, again, and thank you for the marvelous job you did about trying to get as much data for the board as you could, but let me ask you, is there, according to your sampling, again, I'm trying to get a clear sense of what we're talking about here, that the charge is a very large one. The sampling is a very, the finding is a very large one, but if I'm hearing you correctly, any infractions that may occur would be no more than what we would be looking at in a regular election, as far as provisional balloting and people being out of precinct or something along those lines. That's that's my question. So would that be accurate, or am I missing something here?
Well, it would not be necessarily accurate, and here's why. What we're talking about here is flagging, 4,000 voters up front in the process that we know if they come to vote, will have to step aside and vote a paper ballot. And that does not mean that the provisional ballots that we issue will be affected in any way. We still should expect the same number of voters to vote out of precinct and those things that normally happen. And we should still proceed with the knowledge that likely that same number of ballots will have to be adjudicated by the board and decided upon before certification. So what this would mean is that, we know that 41 have voted in person, and as I said earlier, 179 have requested an absentee ballot. I'm not sure how many of those have come back, so I won't estimate that, but we know that there are some on the list that wouldn't be eligible for a challenge because they've already voted their ballot. But those that would be eligible could easily equal, 3,600 plus. And, those voters any of those voters that came in to vote would be in addition to whatever provisional ballots we cast. And did that answer your question, Mr. Dix?
Well, I'm sorry. Oh, okay. Well, no, my question, I'm sorry. Let me be a little bit more direct. My question is, we're actually looking at almost intimidating and disenfranchising a number of people based on clearly on a challenge, which is legal. But my question is, do we have enough information to actually make that does this rise? I don't see where this rises to the standard of probable cause. That's my own observation. I'm just going to say that's my own observation. But I'm sorry. Go ahead. I'm sorry, Mr. Chairman. That was all I wanted to say.
And in so saying, Terrence, you'll have an opportunity to vote one way or the other once we've gone through the remainder of this process and the additional questions that may or may not exist, or additional statements that may or may not need to be said moving forward. Are there any questions before I call the question?
This
Yes,
is Bob
Mr.
Finnegan.
Chairman.
I got another one.
Oh,
The chair recognizes Bob Finnegan.
Okay, yeah. Lynn, you just explained what would happen if one of these voters came to the voting precinct and they would be asked to step aside and cast a provisional ballot. How about those that send in an absentee ballot or mail-in ballot? How would they be? I mean, those would be put, noticed and put into the challenge status. But how would that voter cure their ballot? I mean, did they have to send an affidavit saying, "Yeah, I'm stationed in Korea and I can't make it to the," or I'm in school in Washington State and I can't make it there in person to the hearing, but I have to send an affidavit? How would all that work for those people?
Actually, those individuals would be set up for hearing. There's no cure mechanism in place as there is now for a mismatch or a missing signature on an absentee ballot. A challenge ballot can only be decided upon a hearing. We would notify that voter. Typically, the notice would go to their residence address, and they would then appear at the hearing, and the person who brings forth the challenge would also be at the hearing, and it would be upon the person, the onus would be upon the person who brought forth the challenge to prove to the satisfaction of the board that the voters, that the challenge should be held and the voter's ballot should not count. So that's generally the way that process works. Now,
And if that
understand,
person cannot come?
well, if they can't come, I suppose, again, the onus is on the person bringing forth the challenge. And so if that person can't satisfy the board that this person's ballot shouldn't count, then the voter really doesn't have to do anything. But again, it would depend on the board's impression of what the challenger informed them about this person's ballot. Now we can obviously, we'll be looking at things. You've mentioned military a couple of times. I too have the same concerns about the military voters that are on there. If we, we should, at some point perhaps get a better handle on the analysis of the list. But quite frankly, we, as I said earlier, we have, there's so many absentee ballots that are coming in right now that we're working to validate, verify signatures and whatnot. Monday opens up 3 more advanced voting sites. And so, we are really, really in the trenches with this election. It's going to be hard to divert a whole bunch of resources to this at this time. And then, we had to proceed also with the knowledge that, we do have a limited amount of time during which, or by which, the board would be required to certify its election results. And that's going to be about 10 days after the election. And so, any hearings that resulted from the challenges that may occur would be heard prior to the certification of the ballots. So that's kind of a general time frame of how things would be laid out.
Okay, thank you, Madam Chair.
You're welcome.
And I believe, Marcia, you had a question.
yes, I did, Mr. Chairman. My concern is that I know our poll workers do their due diligence in verifying residents. Would this not help resolve some of the questions that are rising now as to the current residents of that particular voter as they come in? And then my second thing is that with this limited amount of time to really go through the list and give it the amount of attention that I feel is required, for me, that's I'm not willing to move forward.
And again, we thank you for that.
Yes.
We will definitely be giving the board members an opportunity to vote one way or the other as we move forward through this process. Are there any other questions?
Mr. Chair, I do have a question.
Yes, ma'am.
Lynn, you said that in just less than 24 hours, you had found how many that actually had moved out of the county? How many voters?
The state found them for us, but they identified, excuse me, 37.
37.
Okay,
37.
so 37, and what are we going to do about those 37 votes?
Well, those people haven't voted here. Those people are now in other counties in Georgia. They're voting in other counties in Georgia.
Okay.
I know
So,
I spot checked one, and this was a person that had moved to Rockdale County. And this person registered in Rockdale County on October 5th, which means they would have been eligible and in fact voted in Rockdale County for the general election in November. And I suppose if they vote in the January runoff would do the same. I've not had time to look at the other 36, so I don't know when they were transferred, but at some point they were transferred out of Richmond County.
but if this challenge is not accepted, is it not true that that person can come to Richmond County because they are a registered voter in Richmond County and vote?
No, ma'am, it's not true. This person's registration has been transferred at some point out of Richmond County and to these other places. So they are no longer on the list here in Richmond County
Okay.
at all.
So these 37 people are no longer on our registration, our list of voters.
That is
All
correct.
37.
That is correct.
Okay. So they cannot come here to vote.
They
No.
cannot. I mean, the registration deadline is passed. So even if they moved back here, they would had to have been registered by December 7th in order to be included on the voters list. Now, let me put a caveat in there, Sherry. Out of the 37, I physically looked at one voter out of the 37 just because of time restraints. So, you know, I wouldn't swear that none of them were registered here, but according to the analysis that was done by the Secretary of State's office, based on the voter registration numbers that were on the challenge list and that also were on the voter registration list now, they came back and identified that these 37 voters were now registered in other areas of Georgia, one of which I confirmed.
Okay. Thank you.
You're welcome.
So if I may ask a question, Lynn, so the presence of these 37 on the list that are being challenged, Lynn's rise to my question, which is, how do we ascertain the veracity or the timeliness of the data by which this person is challenging these voters? If I could just make a brief statement, you know, I have every confidence in the law that allows for a challenge from one elector to another. And I do not believe that this is being and has been misused. My concern, however, is we're finding that there are people that are actually registered in other counties on this list, but this list is predicated on those individuals being still registered to vote in Augusta, Richmond County. I'm not quite sure that I'm comfortable with the veracity of the list itself rising, in my mind, to a point of action. Secondarily, my other concern is what would preclude someone from creating a list of individuals that lived in a neighborhood or in a specific part of town, and challenging a zip code, every elector in that zip code. Would we then be responsible for adjudicating every registered voter in that zip code based on one person's challenge of that zip code's registered voters? In my mind, it's putting an undue burden on the voter, which I absolutely have an objection to. And it also puts an undue burden on the staff to run down someone else's suspicions that someone is not registered to vote in Augusta Richmond County any longer. It would appear that the system is working properly if you moved to do a data dive and found that a certain percentage of these voters are already registered outside of Augusta Richmond County, but they're still being challenged in Augusta Richmond County. That is problematic to me. And so I want to make sure that those that are listening to and watching this meeting publicly, that the Augusta Richmond County Board of Elections follows the law 100% of the time. I want you all still to understand that the Board of Elections, the members, both the Republican members and the Democrat members, as well as the chair, myself, have 100% confidence in our staff's ability to do and follow the law, and that they do and follow the law 100% of the time. Finally, I want everyone who is listening and who is watching this, either now or in the future, to understand that our voter lists are reviewed every time an election takes place. And when any elector walks up to any poll worker to vote in Augusta Richmond County, their ID is checked, their status as to whether or not they're still eligible to vote is checked, and that person is either allowed to vote in person or they're allowed to vote with a provisional ballot if that's what's necessary, or they are told that they are in the wrong place to vote or the wrong city to vote. But that information is well established. It is in our database, and that database, it's clear that over the last few months, that database has also been purged. It's also been cleaned. It's also been looked at, and it's also been reviewed by numerous people, including our staff, in the proper organizational functioning of their jobs. And so this challenge that is before us, we are taking it very seriously. We do not want to appear cavalier in any way. We want to make sure that every person that votes in Augusta Richmond County is eligible to vote in Augusta Richmond County. And every person that is not eligible to vote in Augusta Richmond County is not going to vote in Augusta Richmond County. That being said, I would very, very much like for the board members to take a moment to review in their minds where they are, ask whatever questions that they may have of Lynn and of Rachel or both, and here in about the next few seconds or whatever it takes for us to come to that conclusion, I'll query the board to find out whether or not you're ready for me to call the question.
Mr. Chair, I would like to just add a comment on that. I
ma'am.
understand that we are charged with making sure that every eligible voter in Richmond County has an opportunity to vote, being through absentee, in person. We've been very concerned about the disabled over the past few years to make sure that everybody has the opportunity to vote and that vote counts. However, it's also my understanding that we have been charged with not allowing any uneligible person's vote to be included in our tabulations. Is that correct?
You are absolutely correct, and I do believe that our staff continually on a electoral basis, making sure that they follow the law, that they are capable of determining whether or not an elector that appears either in person or requests an absentee ballot receives that absentee ballot or receives the ballot at the poll or receives a provisional ballot at the poll according to the laws stated in our election code. Now, we are also charged with having free and fair elections. And we are also charged with making sure that that part of that free process is not creating undue burdens on voters to vote. So we don't ask people to do things at the polls that's unnecessary. And so we need to be mindful of creating obstacles for individuals to vote based on supposition or based on suspicion. If people own property outside of Augusta, they're receiving a bill for that property's utilities or phone or whatever outside of Augusta. Doesn't mean that they live outside of Augusta. Still means that they have property that's outside of Augusta. They may buy a piece of property someplace else in another city, or they could be in the military. All of these scenarios are in place, and we as board members, and I'm challenging each one of you, I'm challenging all of you to make sure that as you prepare for this vote, regardless of whichever way you vote, understanding that we are in the throes of an election right now, and that we are challenged and tasked at this point to our very, very limits to do this in such a way that the voters continue to have confidence in our ability to hold and run elections, which is what we're charged with. That is our overriding charge, is to make sure that we do exactly what Sherry said. Every eligible voter for Augusta Richmond County is going to have their vote counted. And our poll workers are also charged and trained to make sure that if someone shows up to the poll that is not supposed to vote, they don't vote. I have every confidence that that happens in every election. Now, if we have board members who don't think that, which I very much doubt, and I'm not making that as a statement, I do believe that we have 100% confidence in our staff and our board. And I do believe that we take our responsibilities very, very seriously. And I want the public writ large and the electorate writ large to understand that we take it seriously. And that's why we're having such a vigorous debate, because we want people to understand that this is a serious matter and this is not something that we're taking lightly. All right, that being said, questions for Lynn or questions for Rachel? So the question that needs to be called at this point is whether or not we are going to, as a board, let's get a motion based on the challenge itself. And so if we could get Rachel to help us formulate a motion so that the motion is correct and legal, so that we're not in jeopardy moving forward with a challenge based on our motion. So Rachel, if we're going to, if someone is going to motion on this challenge, is it a motion to receive the challenge, accept the challenge, or is this a motion to deny the challenge? Which motion makes the most sense based on the way the challenge is written?
In my opinion, it would be a motion to deny the challenge.
Okay. All right. So at this point, if there aren't any other questions, then I'm going to entertain a motion either way.
Mr. Chairman.
Yes, sir.
I move, Mr. Chairman, this is Terrence Dix. I move that we deny said challenge.
Okay, it's been properly moved that we deny the challenge. Is there a second?
I second that.
Okay, it's been properly moved and seconded that we deny the challenge. All in favor?
Aye.
Aye.
All opposed?
Aye.
So it would appear that we have a vote of 3-1 in this, and it would appear that we have denied the challenge of this elector of the 3,753 votes in Augusta Richmond County. Is there anything else that we need to cover today for the good of the board? Lynn, do we need to do anything else?
No, sir, that was the sole purpose of the meeting.
Okay.
I move we adjourn, Mr. Chairman.
Been properly moved, seconded that we adjourn. All in favor?
No,
Aye.
question.
All
Was that-
opposed? Thank you
Merry
all.
Christmas, everybody.
Yeah, Merry Christmas, everyone.
Merry
Thank you.
Christmas.
Happy holidays.
Bless and peace. Thank you, and thank you, Lynn. Bye-bye.
Thank you.
Thank
Merry Christmas,
you.
everyone. Bye-bye.